Rachel already okay. As Rachel already mentioned, I will briefly talk about the convention, its content and scope, and then the role of the committee, the main mechanisms for protecting migrants' rights of the Committee on Migrant Workers. Then what the convention says and what the committee has been saying about the right to liberty and the protection from arbitrary detention. And finally, just few words about the ratification of the convention. So in terms of just very basic facts on the content and on the convention and in particular on the content and its scope, I will not get into the whole content of the convention, of course, as due to time limitations, but at least some introductory remarks. As you already know, the convention was adopted in 1990, 18th December, by all UN member states, but entered into force in 2003 after 20 ratifications by member states. And nowadays there is 57 state parties, so 57 out of about 200 states that ratify the convention. I will get to that point later on my presentation. This convention is very basic information, but it's the main tool of international law for addressing international migration, and in particular for protecting the rights of migrants and their families. In a way, we could say that there is no new rights there. It's just about human rights, the rights that every human being has through the Human Rights Declaration, Universal Declaration of Human Rights, other international treaties from the international civil and political rights and economic, social, and cultural rights, CERD and other conventions. But what it does, this convention, as other conventions do in relation to other social groups, is just focusing these human rights that belong to every human being to the context of migration and to particular situation where migrants may end up, like situations related to deportation, for instance, family reunification, or other matters that are very close to what migrants can face in the migration process. In terms of content, and this is maybe another complexity that this treaty has, it's the largest human rights treaty. It has 9 parts, 93 articles, which include more than 70 substantive articles. When you compare to other conventions, other UN conventions, you can see how long but rich and comprehensive this convention is. So there is as I said, there is a very big catalog of human rights, civil and political rights, economic, social, and cultural rights, articles on due process, articles related to children's rights, families' rights, other cross-cutting matters, and this comprehensive approach to migrants' rights and to people in the context of migration has been broadened by the committee's dynamic interpretation, as any other committee has been done and have been doing since each human rights treaty had been approved, through the principle of progressiveness of human rights, dynamism of human rights. Other topics have been included by each committee. I mean, including disability issues, sexual orientation, gender identity, and many others that have been included through the use of those key human rights principles. In terms of the scope, as you of course know, I mean, this is a convention of, it says it's a convention of migrant workers, and every single article talked about migrant workers. But and so in that sense, I wanted to flag at least 2 things. Okay, one, the very basic definition of migrant worker in Article 2, in terms of that is everyone that is to be engaged, is engaged, or has been engaged in a remunerated activity in a state he or she is not national. That's the basic definition. But then another important thing is that the convention applies to the entire migration process, even before someone migrates, I mean, the preparation for migration, the departure, the transit, the entire period of stay in host country, and also the process of returning. So when you have this broad approach to the entire migration process, and then you read first the articles of the convention, you realize that it's not just about workers, or because they are workers, or because they are working, or they work, or they are about to work. It's about, as I said, a very long uh, uh, list of rights that protect a number of situations which are disconnected to a working status, to the fact whether he or she is working, or whether he or she is a worker, or worked in the past, or will work in the future. So that's an important thing, because usually, okay, there is a sort of misunderstanding that, okay, this convention applies to workers and whether they are working. I mean, this convention applies to all migrants, despite of this formal name of the convention. When you actually read the article, it's about the entire process of migration and many issues: detention, deportation, return at the border, and ill treatment, and many other aspects may be and usually are not connected in practice, in each case, with work or labor conditions or any kind of issue related to work. And interpretation of the committee through the general comments, through the recommendations to state parties, again, reaffirms that the convention is talking about migrants, every single migrants. Then it includes some article about working, I mean, working conditions, right to work, etc. But in general, it's about migrants. And just another example, all the jurisprudence and the standards developed by the committee on unaccompanied children, even I don't know, a 5 years old girl which is alone at the border. There's nothing about working there. It's not about migrant work. It's about protection of migrants and migrants in very vulnerable circumstances. And also, as you well know, the convention includes, and most of the articles of the convention are applies to all migrants regardless of their migration status. There is only in one part of the 9 parts of the convention that is related, that is focused on those who are in a documented status, that are in a regular migration status. And those articles of part 4 are more linked to those who are in a formal employment relationship, other kind of rights, like as voting rights, that usually in most of the cases in every country, it requires some kind of regular status for being allowed to vote in the country of destinations, and other articles. But even in relation to this part, it's important again to take into consideration the relevance of key principles of human rights law, like progressiveness and dynamism. So as an example, there is an article 43 about education services. When you go to that article and you see even legislation in many states, it's not just about documented migrants, it's about undocumented migrants that can access to training service or other kind of related services where the immigration status shouldn't be a barrier to, in order to exercise that right. And one more thing, and I think it's important thing about the scope. When you read the convention, Article 3 says that the convention shall not apply to refugees and stateless persons unless such application is provided for in the relevant national legislation or international instruments for the state party concerned. So again, my opinion, another misunderstanding, and it's only about migrant workers and because they are working, and there's nothing about refugees or asylum seekers. Again, when you read carefully the convention and articles, and when you go to practice and to what the committee has been saying about protection of people in the context of migration, the scope is much broader. One reason all refugees fall into migrants definition. I mean, they are all persons that are either temporarily or permanently residing in a country where he or she is not national. So every migrant, every refugee is migrant. But not every migrant is a refugee, as you well know. There is an additional legal status for those who are recognized as refugees, but in any case, they are also migrants. They fit into the definition of migrants. So another reason is that apart from whether someone is recognized as refugee and gets this additional status, at the end of the day, in many other aspects, in the exercise of many rights, refugees as migrants, as they are migrants, they are regulated. They access to education, labor rights, health services, justice, criminal law, etc. They are in a way, I mean, the status or the level of access of recognition of these human rights are based on his or her condition as a foreigner. So there is usually there's no two kind of set of rights. Like, I mean, okay, you access to healthcare as migrant to this kind of services, and as a refugee to this other kind of, or your labor rights are these, but if you're a refugee, you have different labor rights. So there's not. Maybe there is some exceptional cases, but so again, when you talk about migrants' rights and migrant workers, we are talking about also about refugees. And the jurisprudence of the committee confirms this broad interpretation. Just few examples. I will not get to read all of them because it would take a lot of time, but just you can see different recommendations for state parties that explicitly includes recognition of refugee status, the protection of people that are refugees, the protection of refugees and persons in need of additional protection. In the case of Mexico, ensure that persons applying for asylum are not detained, ensure that persons seeking refugee status access to free legal representation and the right to an effective remedy. In the case of Turkey, the committees made recommendations to Turkey in terms of withdrawing the reservation, the geographical reservation of the 1951 convention that Turkey did, that assessing the individual situation of migrants in transit, that determining protection needs for each of them in full compliance not only with international human rights law, but also humanitarian refugee law. Recommendations to Albania, Tajikistan, also about asylum seekers or refugees. And in the general comment 5, the last general comment on the right to liberty, when the committee addressed I will get later on to this point again, but when it addressed the concept of jurisdiction and the state responsibility in case of detention of migrant workers seeking asylum. Again, migrants include asylum seekers and refugees. It's a migrant that also is seeking for this additional protection status. Usually, the convention and the ratifications, the low number of ratifications, has been leading to an hypothesis where this only applies to countries of the origin, and there is nothing about that in terms of protecting migrants' rights in destination. Of course, there are many countries, host countries, that haven't ratified the convention yet, but one of the ways or the strategies, because the convention applies to the whole migration process, that the committee has been using for addressing some of the migrants' rights concerns, migrants' rights deprivation in countries of destination that haven't ratified the convention, is through the recommendations of countries of origin, of countries of transit. One way of doing it is making recommendation on bilateral agreements. As you well know, many destination countries has convinced, forced, you take the word you prefer, the signing of bilateral agreement, bilateral readmission agreements, other kind of bilateral agreement that not necessarily include a basic set of rights of those migrants that are being moved into a host country for working purposes, for instance, or they are being forcibly moved from destination country, are being deported, or they are being returned. So because of those reasons and others, the committee has been including some recommendations in terms of the obligations of these countries that are state parties to the convention, of including the articles of the convention in any single policy, which should, of course, include bilateral or regional agreements. So including gender responsive bilateral agreement, non-discriminatory measures for protecting migrant workers' rights, monitoring the enforcement of bilateral agreements, protection for domestic workers, including the convention provisions in readmission agreement, for instance, in this case, between Sri Lanka and the EU, or Sri Lanka and Australia, ensuring that the state of destination doesn't implement collective expulsion measures or other kind of measures that are against human rights principles. I mentioned earlier about the how long is the convention and the different parts that it includes, and one of them, and it's interesting when we are following the number of discussions in the Global Compact of Migration and the Global Compact of Refugees, different bilateral or regional agreements in terms of cooperation and exchanges and so on. The convention does include a section for promoting bilateral, regional, and international cooperation, and the committee in most of the recommendations to state parties again includes specific duties that those states have to fulfill in terms of including the provision of the conventions in different bilateral and regional agreements. No? When they are promoting some kind of multilateral agreement or bilateral agreement, they should include, I mean, due process safeguards and other kind of protection measures for those that will be affected by those agreements. In terms of the role of the committee, the three key roles of the committee, as any other UN treaty body, is the periodic review, the general comments, and the interstate and individual communication. In terms of periodic review, according to the convention, each state party has to submit a report every 5 years. Usually in practice, it might take 7, 8, 9 years, approximately, as it happens with other committees. But the committee has been implementing what we call the simplified procedure. So what it means is that the committee prepares a list of issues, a list of questions, and then the state party has to send a report in replying to that list of issues. And then along with the report, the committee, as I'm sure you will know, the committee receives information for other stakeholders, civil society organizations, national human rights institutions, UN agencies, and right after the committee gathers all that information, and in particular information from the state party, there is the constructive dialogue takes place. And as a conclusion of that dialogue, the committee makes recommendations in terms of which policies should be reformed and which changes should be implemented by each state party. The follow-up, of course, is every periodic review, but the committee, as it was done also by the other committees, makes some or adds some priority recommendations in the concluding observation that has to be reported in terms of the measures implemented by each state based on that recommendations after 2 years of the recommendation. And in terms of strategies or initiatives for following up, that recommendations. One option that was approved by the committee and so far is in process in terms of how to improve and how to effectively conduct that kind of follow-up initiative. It's in situ follow-up in the field, in the country, and this kind of follow-up strategy is currently under discussion in what is called the TD bodies strengthening process. The periodic review, why, in my opinion, is important. It includes different and several opportunities for civil society engagement. First one, providing information for the adoption of the list of issues. I mean, the questions that the committee will send to the state party, I mean, can be informed by information received from civil society and other stakeholders. So a report that with suggested issues and questions to be sent to state parties, that report could be also complemented by virtual or in-person meeting with the committee. Then what it follows is the process of elaboration of the state party report by after receiving this list of issues. That, in my opinion, is a key opportunity for advocating for public policy reforms. Why? Because each state party of this convention or to other conventions usually tend to send a report that include good practices, include some kind of improvements, some kind of new policies or new pieces of legislation or new measures, new practices or procedures that the state put in place in order to fulfill the recommendations made by the committee in the previous reporting process. So that is a sort of period that tend to be critical for having some kind of dialogue or advocacy strategies for policy reforms. Then civil society can send again more information for the constructive dialogue after the state send the periodic report. So the civil society usually sends alternative report, but also there's a possibility of having virtual and in-person meetings with members of the committee. Of course, the civil society has a critical role for dissemination of the recommendations and then setting some kind of strategy, advocacy strategy for making state party implement the recommendations, and in the entire process of the follow-up, the participation in follow-up national mechanism in the case that exists in some states, sending an alternative report to this intersessional follow-up report after 2 years of the recommendations, but also civil society can promote other kind of follow-up strategies, including country visit by the members of the committee, for instance. General comments, why they are important. They are, I always tend to say that they are like the tiny letter of human rights treaties, but it's not only the tiny one, but it's the updated language of the convention. So it's a key tool for ensuring treaties as living instruments through the principle of dynamism. So it allows the committee to adapt the language of the treaty to and the goals of the treaty to current trends, needs, and challenges. Which general comments the committee adopted so far? Number 1 on domestic migrant workers, 2nd on undocumented migrant workers, 3 and 4 with the Committee on the Rights of the Child, on the rights of children in the context of international migration, and the last one on the right to liberty and protection from arbitrary detention. Just few thoughts on this. The convention, as other conventions or additional protocols in some cases, includes interstate communication and in particular individual communication, which is regulated in Article 77. These are key mechanisms because it's it leads to the development of case law. They are opportunity for additional as an additional protection tool for migrants and his family, and to be used for by civil society, national human rights institution, or other kind of stakeholders. And this case law can impact on public policy practices procedure. Unfortunately, this procedure hasn't entered into force yet. Why? The convention in that article requires 10 ratification from state parties. This 57 from these 57, only 4 ratify this mechanism: El Salvador, Guatemala, Mexico, and Uruguay. So there is a need of 6 more ratification in order to allow the committee to develop the procedure, and then having this procedure available for those that want that or need to submit an individual communication in case that some migrants' rights or the family's rights have been violated. Right to liberty. Article 16 and 17 are the ones that regulate not in a very in-depth way the right to liberty, and includes very basic standards, very classic in a way, standards on the right to liberty, protection on arbitrary arrest and detention, principle of legality, the right to be informed of the reason of migrants' arrest in a language they understand, right to consular assistance, right to take the proceedings before a court, right to an interpreter, compensation in cases of unlawful arrest or detention, right to be treated with humanity, the detention of migrants due to immigration grounds should be conducted in places different from those for convicted persons or persons detained pending trial. But I will go to the interpretation of these 2 articles and other articles, connected articles, by the committee. In general, comment 2 on undocumented migrants, the committee established 2 critical standards, which is detention as a last resort measure due to immigration detention as a last resort measure, and the principle of exceptionality of detention as the general rule that states must fulfill. Then, in the joint general comment with the Committee on the Rights of the Child, number 3 and 4, the key standards there are that any immigration detention of children is against child best interests and violates children's right to liberty. Prohibition of detention of children and families, also families, not only unaccompanied children. In the case of family, both committees said, due to the right to family unit and plus the right to liberty of children's, family should be out of any kind of immigration detention, rather than using family units to justify the detention of the whole family. Consequently, states had the duty to eradicate immigration detention of children and families. Resources dedicated to detention should be diverted to non-custodial solutions carried out by competent child protection actors. So instead of detention, there should be measures in terms of child protection, alternative care measures, and again, with a key role of child protection and welfare authorities rather than immigration authorities implementing these alternative care measures disconnected to immigration control policy goals. General comment 5, the last one, some of the introductory standards developed by the committee is describe some practices of immigration-related detention that amount to violation of migrants' rights. Reinforce, as it did in General Comment 2 and 4, the provision of criminalization of irregular migration. It describes some regressive practices in 1990s, the expansion of detention worldwide in every region, or most of regions, which has, the committee adds, become an industry. The multiple effects of immigration detentions are described in paragraph 6. The main objective of this general comment is providing guidance to states on fulfilling their obligation under the convention in relation to the right of liberty and protection against arbitrary detention. And then the committees define like the content and the scope on the right of liberty and protection against arbitrary detention. In terms of definition of deprivation of liberty, as it did again in previous general comments, such as General Comment 4, the committee adopts a very broad definition in terms of any forms of detention or imprisonment or the placement of a person in a public or private custodial setting which that person is not permitted to leave at will by order of any judicial, administrative, or other authority. Such deprivation of liberty begins at the time of arrest and extends until the person is released. Another important remark by the committee is its concerns about the terminology used by many states. No, the euphemism that usually used for naming detention practices. That, according to the committee, those terms are usually intended to prevent those measures from scrutiny, thus avoiding procedural safeguards that should be applied before and during any deprivation of liberty. And apart this broad definition, of course, we are talking about immigration detention. So it's detention based on reasons related to immigration status, that is a person's migratory or resident status or the lack thereof, whether relating to irregular entry, stay, or exit. Few more key important aspects of this General Comment 5. It stresses or it reaffirms what other committees said about jurisdiction, and also the CMW in General Comment 3. The principle of effective authority, de facto or de jure. So it's not only about detention in state's territory, but in any place outside the territory where states exercise authority on a person. So state authorities participate in acts that violate human rights when design, financing, administrate, or supplies places of detention abroad. If a state party decides to move migrants to detention centers outside its territory, the state is obliged to ensure the rights recognized in the Convention and other human rights instruments. If migrants seek asylum and are transferred to places of detention outside the territory of the state, the cases should generally be processed in the state where they are, or the state that has jurisdiction over them. And an important addition, if states reach agreements to transfer asylum seekers for processing their cases, they cannot dismiss their obligations under international human rights law, international refugee law, and criminal law. And in terms of privatization of immigration detention, the committee stressed the state duties in case of involvement of private actors. If a state subcontracts the management of or security of immigration detention center to private enterprises, it remains responsible for conditions in which they hold individuals in detention. And it asks that in principle, security personnel in detention facilities must be from the public sector. Some fundamental principles of this general comment: non-discrimination, non-criminalization, exceptionality of immigration detention, non-detention of migrant children and families, and including reaffirming General Comment 4, but including OHCHR and other key stakeholders' positions on this, the non-detention of other persons in vulnerable situations. Those who are particular risk of exploitation, abuse, gender-based violence, including sexual violence, pregnant and breastfeeding women, older persons with disabilities, survivors of torture, persons who are victims of crimes such as trafficking, etc., etc., etc. In terms of legal obligations, the committee refers or links this part with the Global Compact in terms of the commitment of all states signatories to this compact to abolish immigration detention, to work towards the abolishment of immigration detention, the duty to consider alternative to detention before imposing a detention in each individual case, obligation to review and implement all available alternative measures before resorting to detention, in accordance with the principle of necessity and proportionality. Alternative measures that emulate measures of criminal justice are excessively restrictive and are not appropriate in the context of migration. And then some classic principles and principle of legality, the limitation of in duration, non-discriminatory, not arbitrary, subject to procedural safeguards, regular judicial review, and independent supervisions of any deprivation of liberty. And complementary in terms of due process access to justice, there is a set of due process guarantees or safeguards when it comes to protect migrants that could be subjected to any immigration-related detention: free legal aid, interpretation, consular assistance, right to be notified of the decision, right to appeal, legal remedies, judicial review, right to be informed of the reason of the detention, reparation measures when it applies. And finally, other standards that are developed. I don't have time to get into each of them, but some standards in terms of provision of ill treatment, slavery, the duration, provision of indefinite detention, the protection of right to privacy and family life, right to health, property, non-punitive facilities. That's important. That could be more developed. No, I mean that this kind of facilities shouldn't be any like in any mean like the ones aimed at I mean for criminal purposes, monitoring mechanism, access to information, among others. Apart from the general comments, state parties recommendations to state parties by the committee, there is a large jurisprudence in terms of that. I do recommend to read some of them, because in a way they not only in some cases I mean they advance what then last year became the general comment 5, but also they are all means of that that ratifies why the convention is a living instrument. No? So recommendations to Mexico urgently put an immediate end of deprivation of children, of liberty of children and family, ensure effective and immediate action regarding process of identification and referral of person in vulnerable situations. Develop a plan of action to ensure that immigration detention of adults is applied only as a measure of last resort. Warranty alternative non-custodial measures in law and in practice, due process, etc. Recommendations to Chile in terms of not only about non-detention, but also addressing irregular migration from other lands, such as the establishment of ordinary regularization mechanisms. The use of alternative measures, the use of administrative detention for migration-related matters only as a measure of last resort, the total provision of detention of children. Again, recommendations for protecting the right to liberty, but through consular assistance. So we are talking about migrants that are detained in host country that haven't ratified the convention. So the committee has been making more recommendations through this country of origin in order to, in a way, impact in terms of reducing the use of immigration detention, protecting the right to liberty of those who are in those states and are subjected to immigration detention. So recommendations on bilateral dialogue, on strengthening consular assistance, protecting migrants' rights against detention through, again, memorandums of understanding with receiving states, and so on. Recommendations of non-criminalization. So policy reforms, legal reforms that states party has to implement in order to abolish or decriminalize irregular migration. Amend legislation in order to ensure that it's used only as a last resort and for the shortest time possible, and non-custodial alternatives are promoted. And last point, in terms of the ratification, as it was mentioned by Michael and Rachel in the introductory remarks, in 32 years, there is only 55 ratification. When you compare to CRC, that was adopted only 1 year before the Migrant Working Convention, and nowadays has 96 ratification on the whole UN member state except the US. In terms of regional ratifications, there are 25 countries from Africa, 10 from Asia, 18 from the Americas, 3 from Europe, and 1 from Oceania. And when we talk about ratification, I always tend to remind what all UN member states unanimously said in 1990, in 18 December of 1990. The importance of migration, the extent of migration involving millions of people, affecting a large number of states, nowadays are much more than 32 years ago. The desire for establishing norms that might contribute to harmonization of the attitudes of states and accepting basic principles on the treatment of migrants, the situation of vulnerability in which migrants find themselves, states convinced that the rights of migrants had not been sufficiently recognized everywhere and that they required appropriate international protection. Human problems involving migration are even more serious in the case of irregular migration. So consequently, states affirm that appropriate action should be encouraged to protecting their fundamental human rights. Workers, undocumented workers, or in irregular situation are frequently employed under less favorable conditions. Granting rights to migrants and their families will encourage all migrants and employers to respect and comply with the laws and procedures. And the need to bring about the international protection of the rights of all migrants, reaffirming basic norms in a comprehensive convention to be applied universally. There's more need than ever of this kind of commitment that every UN member state did 32 years ago. There are some arguments against ratification that the convention provisions are already included in national legislation on some states. Something that could be replied to that. I mean, those states have also national legislation, for instance, on the rights of people with disability. And that wasn't an obstacle for them to ratify the CRPD or other kind of convention that on matters that have strong legislation in those states. And so that's not a real reason. Then some state that there are too much rights for undocumented migrants. When it comes to analyze the jurisprudence and the language of all other human rights treaties, such as the Covenant of Economic, Social, and Cultural Rights, the Convention Against Torture, and Convention on the Rights of the Child, and what the committees have been saying about migrants in an irregular situation and asylum seekers and refugees, they don't not only ratify and reaffirms what this convention said or what the committee has been saying, but in some cases they have even wider standards, such as, for instance, the Committee on Economic, Social, and Cultural Rights on the right to healthcare services, which is not only about your emergency services, but every basic health services, including preventive health services. Another reason usually mentioned, the convention has already been ratified by countries of origin. That's not true. And nowadays it's much less false, much less true, sorry. Look at the reality and the huge and complexity of challenges that some state parties are facing nowadays. Turkey, Morocco, millions of asylum seekers and refugees in Burkina, the situation of Egypt, Libya, Syria, Bosnia, as also transit and receiving country. Colombia received 2 million Venezuelans in the last 5 years. Ecuador, about 1 million. Peru, the same. Chile, pretty much the same. Argentina has been a receiving country for more than 100 years. Mexico copes with one of the more challenges context in terms of human mobility. Maybe the common characteristic is that they usually, most of them has much less capacities and resources to address these challenges in comparison with many other UN member states that haven't ratified the convention. And as Mike just said in the introductory remarks, are evidencing nowadays that they do have the tools, and if they have the will for receiving those who need protection, that are moving, in this case, from Ukraine because they need protection, because they need receiving policies, hosting policies, and many public policies to be put in place in this humanitarian displacement context. So that's, in my opinion, the key reason behind non-discrimination is just a lack of political will. Xenophobic context, toxic narrative about migration. That can't be another explanation for that. For this unanimous approval 22 years ago, and now that 3/4 of UN member states haven't ratified the convention yet. Last points, why ratifying the Migrant Working Convention? First of all, very basic. It's very, very basic commitment with the international community that each UN member state can make. Actually, many states that haven't ratified the convention have developed regularly strategies directed to other UN states for ratifying other treaties, like CEDAW. No? I mean, I'm pushing for the ratification because it's a very basic commitment to international community. So what about this commitment? What about the preamble of this convention that they accepted and approved? That would be coherence with that goals. That is, they are more needed than ever since then, and there are not other international tools. Of course, migrants' rights are covered by by all international human rights treaties. So you can focus, you can access to migrants' rights, to economic rights and social rights, to civil and political rights, to children, to women, to people with disabilities, through protecting from enforced disappearance, from torture, from imprisonment. But in this case, you can address all of these matter and others all together. This idea that states have been repeating and repeating all over again for the last 2 decades, comprehensive policies. Okay, this convention has a comprehensive approach. Could be better, of course, but then you have dynamic interpretation, progressive interpretation as a living instrument that allows everyone to make this comprehensive and updated in terms of interpretation. So you have the possibility for discussing in a normative, international normative framework, this comprehensiveness of the convention, all these dimensions that characterize international migration. So it's a key international tool also for accompanying the fulfillment of the goals of soft law political process, but with legal commitment, like the CCM or the SDGs process. Again, ratifying the convention, having the possibility, the periodic possibility for addressing in a comprehensive way all public policies that impact migrants, impact asylum seekers, that are related directly or indirectly to human mobility. It's a unique opportunity. There is no other platform, legal platform within international human rights law to do that. So that's it. I will stop here. I don't know if sorry if I've respected the time. Sorry for that if I didn't. Thank you.
No, that was fantastic, Pablo. Thank you very much. That was extremely comprehensive, and you really covered, everything that we had hoped that you would, from the general scope and content of the convention to how it specifically can be applied to situations of deprivation of liberty and detention and arbitrary detention, how civil society organizations can engage with the convention and the committee. And then finally, these really important points about the big gaps in ratification. And as we saw in that slide you showed us, big geographical gaps as well. Very few European countries that have ratified, very few northern countries, industrialized countries. So definitely very big gaps. And one of the reasons why we invited Yao Zhang from OHCHR to speak next is because the Special Rapporteur on the Human Rights of Migrants has a mandate that covers all countries. So those who have ratified and those that haven't ratified the CMW. And so we just thought it would be very interesting to hear from you, Yao, you know, briefly if possible, but what is the scope of the mandate of the Special Rapporteur? How can he engage with countries, especially those that may not have ratified the convention? How can civil societies engage with the Special Rapporteur? And what's the synergy between the mandate of the Special Rapporteur and the Committee on Migrant Workers? So I know you've got to go, so I'll quickly hand over to you, and we'd be delighted to hear. And if you have any questions for Pablo or Yao, please start thinking about them for the discussion that will be coming up next. Thank you.
Thank you so much, Rachel. And thank you so much, Pablo, for this very comprehensive presentation of the work of the CMW. I've also learned a lot from his presentation. So indeed, the Special Rapporteur on the Human Rights of Migrants is a different mechanism. I believe the major difference is that the SR mandate is a charter-based mechanism and the committee is a treaty-based mechanism. So we do work together, we collaborate. I will give like a brief introduction also on how the SR works, but in terms of collaboration, the two mechanisms, we work together, like the SR meets regularly with the members of the CMW. They exchange views on the current issues, on the pressing common concerns, and they also look at possibilities to work together on joint activities such as joint statements, joint guidance notes, and also whenever there's relevant consultation topics, we do share information with the committee. And then through the work of the Special Rapporteur on the Human Rights of Migrants, we also encourage member states to ratify the convention whenever that is appropriate. We also make reference of the important work of the CMW, the concluding observations and the general comments in the Special Rapporteur's work in his bilateral communications with member states, and also in his thematic reports that he submits to the Human Rights Council and the General Assembly. And the scope of the mandate of the SR, as Rachel mentioned, that is very wide. Geographically, we can engage with all member states, countries of origin, countries of transit and destination. We also, our actions do not require exhaustion of domestic remedy. So the SR is able to take action on very pressing measures whenever the capacity is allowed. And the SR also covers migrants of all profiles, migrant workers, asylum seekers, undocumented migrants, and all those in irregular situations. So the mandate was created in 1999 by the then Commission on Human Rights. The mandate is created to examine ways and means to overcome the obstacles to the full and effective protection of the human rights of all migrants at all stages of migration. And then, of course, the mandate is created to elaborate recommendations on strengthening the promotion, protection, and implementation of the human rights of migrants. The current mandate holder is Mr. Felipe González Morales, and he has been the mandate holder since 2017. The mandate is supported by the Secretariat of OHCHR staff. Maybe just very briefly on the methods of work. So from there, I believe civil society partners could, this is also linked to how civil society partners could collaborate with the mandate. The mandate has a communications procedure, and through the communications procedure, the mandate holder can address country-specific situations of groups of migrants. As I mentioned, we do act on all countries. There's no there's also no requirement of exhaustion of domestic remedy. And the mandate holder conducts country visits, normally 2 visits per year, but since the pandemic, unfortunately, we haven't been able to do so. And the SR submits reports to the Human Rights Council and the General Assembly on the most pressing thematic concerns of the mandate. The most recent report has been on pushbacks and also the COVID-19 impact on the human rights of migrants, and also ending immigration detention of children, where we worked very closely with the Global Detention Project. The future report of the SR to the June session this year would be also on human rights violation at international borders. And then for the next GA session in October this year would be on climate change and the protection of the human rights of migrants. The last report the mandate holder would like to submit to the council would most probably on the regularization of migrants in irregular situations. So what else do? We do engage with member states through bilateral meetings, through private meetings, communications, country visits, and consultations. We also follow the GCM implementation process. The SR contributed to the regional reviews, and he's also committed to contribute to the International Migration Review Forum. He's also a member of the steering committee of the UN Partner Trust Fund for Migration, and he's actively engaged in several interagency working groups on thematic topics. So for civil society partners, we do collaborate with you, and we welcome and we appreciate your work. There are ways to work with us. You can, for example, submit cases of country-specific situations through the communications procedure on allegations of either past or ongoing human rights violations against the migrants, or allegations of concerning bill, legislation, policy, or practices that are not in compliance with international human rights law and standards. You are also most welcome to provide inputs to the thematic studies that the mandate is conducting. We do send a call for inputs, and you can find our call for inputs on our website in this regard. And this would help the SR, this would inform the SR's reports, the annual report, to the council and or to the GA. And you are also most welcome to provide information ahead of, during, or after country visits. We do reach out to partners to seek information before the country visit during the preparation period, and we do meet with civil society on the ground when the SR is conducting the fact-finding mission. And of course, we'll also appreciate your contribution in the follow-up of the implementation of the recommendations of the SR to the country concerned. So I think that's pretty much from my side. I try to stay brief. Thank you so much for your attention.
Thank you. Yeah, that was amazing. That was 100 miles an hour run through the entire mandate of the Special Rapporteur, but I think that was very helpful for us to hear about that, to see how you do collaborate with the Committee on Migrant Workers and work with them on joint statements and support their work and publicize and call for adhesion to their work and for ratification, but that you can also work independently yourself and take up issues through these fact-finding missions and even also urgent interventions on pressing issues. So that was really helpful, and we will, if it's okay with you, we will share the contact information for the Special Rapporteur and the Secretariat when we follow up on this meeting. I want to move on now because we do have some regional experience from different NGOs here of how you have engaged with the Committee on Migrant Workers and the application of the Convention on the Human Rights of Migrant Workers in your regions. Or some of you would are not parties to the Convention, but are going to talk about the real pressing needs and how the Convention and ratification would be useful in your region. I am going to ask you please to be very brief. So please limit your comments to 3, maximum 4 minutes, and I will cut you off just so that we have a chance for everyone to put forward their questions and discussions. So the first speaker is representing Migrant Forum Asia and is from the Refugee and Migratory Movement Research Unit in Bangladesh. Bangladesh is a party to the convention, and I'd like to welcome Dr. Chowdhury Abra, who is the director of our MMIU.
Thank you.
Dr. Abra.
Can you hear me?
We can hear you. We can't see you, but we can hear you.
Right. Okay. No, I didn't expect that I'd be called first. In any case, as you rightly said, that we successfully organized the ratification of the convention, and for that, I'm deeply indebted to our partners, Migrant Forum in Asia. And very briefly, I will narrate that it has not been high on the agenda of the government, although Bangladesh is dependent on migrants and that should have been high on the priority, but that was not. And it needed very sustained, campaigning on the part of civil society organizations. And that's what we had done. The final push came when MFA facilitated the then chair, Mr. Al-Jamri, the committee chair, to come to Dhaka and then address interministerial meetings, met individual ministers, and basically who's who in the government, the Parliamentary Standing Committee and all that. And finally, he secured the promise that Bangladesh is going to ratify. So that was one. That's how we had done that. There were a lot of misgivings, and there's a lot of turf war between ministries. And so those were all put to rest. The second issue, what I would say is, in our campaign, we used the good things that government wanted to bring, order in the recruitment sector. And what we said was, this is exactly the type of things that you should be doing. And the convention basically encourages you to do that. So you identify the areas which would induce the government, to move on. My final point is, for some reason, we have found the acceptance of GCM and SDGs, the way it was accepted and celebrated for some reason at the same sort of pace. I think there was a retreat about commitment, with regard to the convention, and this is mind-boggling, and this is where I think, I'm going to suggest that perhaps, it has undermined to an extent, the convention, that we have this non-binding, procedures in place, and thereby you are, dispensing of something where you're under legal obligation. So to what extent we achieved these at the cost of the convention, that's something I think we need to, reflect. I'll stop there. Maybe a bit, sort of hard statement, but I thought I should flag it. Thank you.
That's a very interesting point, and I think in the discussion we may want to bring up the GCM and maybe hear a little bit from Pablo as well. I mean, you mentioned that some of the general comment on deprivation of liberty was aligned with the GCM, particularly on alternatives to detention. But what has the interaction been like between the GCM and the convention? To what extent can the GCM be a process that pushes for more ratification of the convention as well? I think is something would be interesting to discuss a bit further. So that was from the Asia region, and we're going to go now to the Gulf states, to Rima Kalush from migrantrights.org. Obviously, Gulf states are more destination countries for migrant workers, and I know that you have done a lot of work on this issue. You've engaged with the CMW, and you have a lot of experience that I think would be very valuable to share with us. So over to you, Rima.
Thanks, Rachel. Yeah, so as you mentioned, none of the countries in our region have ratified the convention. Most of them still maintain that they don't have any migrants at all. So on our end, we do maintain a call for ratification. We were really involved in the Step It Up campaign that was launched for the CMW's 25th anniversary a few years ago. The reality is that there is really limited representative governance in these countries. So we can't really, rally the public around ratification. or make it an election issue, which is what we've seen in some sending countries. And we don't really anticipate the needle moving on this anytime soon. But that being said, there are still, of course, a lot of opportunities to engage with the convention. And I'll give a few examples of what we've done so far. So engaging with the Special Rapporteur on migrants through submissions and joining informal consultations and providing briefings ahead of country visits. We found the Special Rapporteur and Yao specifically to be very accessible and really interested in obtaining civil society inputs from the region. And we're also really sure to reference the CMW in submissions to other special rapporteurs, to working groups and treaty bodies, etc. A really good example actually is a co-submission we made with GDP to the Working Group on Arbitrary Detention ahead of their visit to Qatar in 2019. And this was cool because we were able to kind of seize on a pretty unique opportunity to comment on a few of Qatar's own reflections on the CMW, as they had just recently responded to a questionnaire that the Committee on Migrant Workers had circulated for an upcoming general comment on detention. And making submissions to these draft general comments is also something that we've done. Only once so far, but we hope to continue to do it in the future. It provides a really important opportunity, I think, to sort of ensure that the issues in our region are captured on the global agenda. And the last thing that we've been really conscious of doing most recently is to ensure that we're referring to the convention, and its standards and recommendations in our contributions to the IMRF review process, which the Gulf states are very active in. I think we share, Chowdhury's concerns and the concerns of others that the GCM can kind of be used to overshadow the convention. And in our experience, at least the past year of, regional consultations and preparatory meetings have kind of cemented this. There's been so much focus on declaring progress made and highlighting best practices without actually evaluating, how these practices or how the status quo generally is promoting and protecting human rights in line with international standards. And so we think there are still opportunities for us as civil society to try to make the convention more visible in the process. So that's a very brief and quick overview of what we've been doing so far. I'm really grateful to Yao and to Pablo for helping us to understand other ways that we can continue to engage with the convention and with the committee going forward. So thank you.
Thank you, Rima. And that was really, really helpful because there, as Rima said, you have a region which is a huge destination region, but none of the countries have ratified the convention, and there's very little traction or hope that they will in the future. And yet migrantrights.org has engaged very actively in referencing the convention, in making submissions for on general comments, making submissions to other bodies like the Special Rapporteur on the Human Rights of Migrants or the Working Group on Arbitrary Detention, and also using the GCM regional consultations to advocate for the standards of the convention to be adhered to, which goes back to Dr. Chowdhury's point, which is, these are standards that are written in law and are stronger in a way than the general principles and hopes and aspirations of the GCM. And so it's very important to keep referring back to those standards. The next speaker I have is Rim Nozi from Gadem in Morocco. So as we heard from Pablo, Morocco is a party to the Convention on Migrant Workers. It has ratified the convention, and Gadem has experience of reporting to the CMW on progress made in Morocco in its adherence to the standards. So we're very interested to hear from you, Rim. Thank you.
Okay, so thank you. You can hear me?
Yes, very well.
So hi everyone, I am Rim Nozi. I am in charge of legal follow-up of foreigners' rights in the interest group for the support and defense of foreigners and migrants in Morocco. It's called the GADEM, For those who don't know, it is an association created on December 2006 by a group of activists and researchers who have been working for years on migration issues, and more particularly on the defense of the rights of foreigners and migrants in Morocco. So our mission is to contribute to the effective implementation of the rights of foreign and migrant people in Morocco. And over the years, we have maintained a strong involvement in the field, which allows us to follow up on the application of the rights of people in migration situation and their situation in general. With regard to the application of the Morocco of the Convention and its relationship with the committee, Morocco have signed the convention at he has signed the convention at 1991, and it has ratified it at 1993. Before the convention came into effect at 2003, but Morocco did not publish the convention on the official newspaper until 2012. However, Morocco has made a reservation. He does not consider itself bound by Article 92, paragraph 1 of the convention. We believe that Morocco has signed the convention as a country of immigration to protect his nationals living abroad. But over the years, it has become a country of transit and settlements. So the context has changed, and Morocco's first report was due in 2004, but it was not submitted until 2012. Then the committee sent to Morocco the list of issues to be taken up in the connection with the consideration of the initial report. It was at this right moment when GADEM was able to intervene just before to influence. I'm sorry, I just have to cut off the phone.
Go ahead, Ruth.
Yes, so I was saying that it was at this moment when GADEM was able to intervene just to influence the list of questions. And it was supported by Global Detention Project. I think it was Michael Klein. I wasn't working in GADEM at the time, but it was a good way to influence. So there was this first report, and it was a really short report. And after that, GADEM coordinated the shadow report prepared by a group of organizations active in the field of migration and human rights, which was submitted to the committee on August 2013. It was an alternative report. Then the committee has held its sessions from September 9 to 13 and examined on September 10th and 11th the initial report of Morocco on the implementation of the convention. It must be said that the pre-2013 environment was very different from the post-2013 environment in Morocco. To have an idea, you just have to look at the GADEM press releases and the alternative report that is available on its website to learn a little more, because I can't due to time. So on September 9th, a thematic report on the situation of migrants and refugees in Morocco was released. It was prepared by the National Council for Human Rights. So it was at the same time. And on September 10th, there was some directions from the king to the government to develop a comprehensive immigration policy and operational action plan. And thus, in the very period when the committee was holding its sessions, a new immigration and asylum policy was announced in Morocco. So it was a particular context, and it was marked by a sort of rupture. We don't know how influential the GADEM shadow report was, but what we know is that it was a good advocacy tool in Morocco. We could use it since the context allowed it. GADEM presented the report to the embassies, which helped raise awareness in Morocco. However, to conclude, GADEM has issued some recommendations that are still up to date, on which there has not been much evolution. In particular, the decriminalization of irregular migration, the stay, entry, and exit, which has a huge impact on the stay and the stability of the migrant workers and their families. We were talking about like the rights of undocumented workers. The second recommendation urgently addressed the problems of mistreatment and other acts of violence committed against migrant workers, regardless of who commits them, ensuring that they have access to independent complaints mechanism, legal counsel, and interpreters. In practice, there are still so many blockages to ensure that any act of torture or cruel, inhuman, or degrading treatment, as well as any of the lives of migrant workers, are investigated and prosecuted, and to create a monitoring mechanisms to ensure that deportations of migrants are carried out in strict compliance with the international standards of fundamental rights of migrants, and to ensure that the access to education and to health, and finally to put an end to the obstacles of to the registrations of birth in civil registers. So I hope I was brief, and that was it.
Thank you, Rim. That was actually really, really helpful, because that was a very concrete example of a country that has ratified. So we heard from Dr. Chowdhury about how the campaign to ratify, and we really heard from you. Morocco was one of the first countries to ratify the convention, and how you as a civil society organization engaged with the CMW, but also used that for your advocacy. And you've had made some progress, and there are still outstanding issues, which no doubt you will bring up again the next time Morocco is reviewed by the committee. So that was very, very helpful. And now we're going to a country which hasn't ratified the convention, but has a huge issue with migrants. And I'm very happy to welcome Olga Abramenko from Memorial Anti-Discrimination Center to talk to us about the situation for migrants in Russia. You're very welcome, Olga.
Thank you very much. Our organization is an ex-Russian NGO, which had to close its office in Russia and move to the European Union due to political repressions. And our cooperation with the committee has some points. The first of them is submissions of alternative reports. We've done it on Kyrgyzstan, Tajikistan, Azerbaijan, and now we prepared again a list of issues on Kyrgyzstan. The specifics of our region is that the main destination of several million working migrants and the main violator of their rights is Russia, which of course is not a state party of the convention. Migrants come to Russia mostly from Central Asian ex-Soviet countries, Uzbekistan, Kyrgyzstan, and Tajikistan, as well as from Moldova, Ukraine, Belarus, Armenia, Azerbaijan, and much less from Georgia. So we are limited in our critics and have to address it to the donor countries. We call them to strengthen their efforts on protecting their citizens working abroad, to influence on the Russian migration policy, which is very harsh. And for that, it's curious, but for that we are actually sometimes are being criticized by the committee. For example, during the last session on Azerbaijan, we were asked why we are talking about Russia while we are discussing here Azerbaijan. But finally, we were happy with the recommendation of the committee, who took our expertise and vision into account and recommended Azerbaijan to strengthen their efforts on protecting their citizens working abroad, and we consider is very important for the promotion of the convention, even in the non-ratifying countries like Russia. The second point of our interaction is inputs for the general comments. We work a lot on the issue of immigration detention of migrant children. In our region, this procedure, the procedure of repatriation of migrant children is regulated so far by a very much outdated agreement between ex-Soviet countries, and this document is of the early post-Soviet era. So it's really important to replace this outdated legislation with the bilateral agreements, which would take into account the modern human rights and children's rights standards. So we consider very important the to join general comments number 3 and number 4 of the Committee on Migrant Workers and the Committee on the Rights of the Child. And we are happy to have opportunity to make an input for this very important documents. And my last point is about what sometimes happens if you cooperate with your own bodies. Our organization was repressed in Kyrgyzstan for submitting a report to the Committee on Migrant Workers. The report itself was included into the list of extremist materials, and our activity was banned in the territory of Kyrgyzstan, and it took a lot of efforts and time to appeal against this decision. We finally won, but it really was a challenge to work on our issues, on the rights of migrant workers. Thank you.
Thank you so much, Olga. And I think what you really helped to highlight there was something that Pablo spoke about in his presentation, that the convention can also be used by sending countries to try and get agreements with destination countries through bilateral agreements, but also through making recommendations. And you've shown that so clearly in your regional approach by making submissions when sending countries are being reviewed, but really they're about the treatment of their nationals in Russia, which is the country of destination. And obviously your last point, and as you introduced your organization, that you're now being banned from Russia, and the reprisals that you received having done that submission on Kyrgyzstan, and that, you know, the how the security risks and the dangers of doing that is something which is very salutary for us all to hear. I really think it was very rich to get those perspectives from people working in different countries and regions. And I'd like to open up the discussion now. If I see that, so there's a few questions in the chat. Yao has to leave, so thank you very much, Yao, if you're still here, but I think you may already have left. There is a message from Elaine Sana, which I don't know if you would like to speak, Elaine, or whether you would like me to just read out your question. But your question is, with the GCM in place in more than 150 member states voting yes to it, do you think this commitment can translate to increased interest in ratifying the CMW, or will it further lessen the interest of member states to ratify? So that's one question that it would be great to hear your feedback, and several people have touched on that. Also, if we have any other participants who would like to speak about their own country or regional experience and share that, I think that's also very rich. But Maybe Pablo, you'd like to respond to that question about the GCM first. Oh, and Elaine, would you like to add to that question?
No, it's okay as you read it, and yeah, I will be looking forward to Pablo's thoughts about it. But maybe just wanted to share as well that the Philippines is also a state party to the convention, and we are supposed to I think the state report is overdue. I think a year or two ago we were supposed to have the revalida, but then it didn't happen. But early this year, or was it last year? I'm getting confused. The committee met to agree to adopt the list of issues prior to reporting, which we managed to contribute some inputs to. And we are preparing, but then again, I think the point is if the Philippine government will honor its commitment to submit a report, then hopefully our own submission will be considered or will be relevant. So we have to really wait and see if the Philippines will honor its commitment, which is actually delayed already by a year or two. So just to share, and this is going to be the third state revalida of the Philippines since it started in 2008-9 session, followed by the one in 2014, and then this one supposedly. Yeah, so that's all. So I look forward to Pablo's thoughts on the GCM and the CMW. Thank you.
Yeah, thank you, Elena. And I should add that Elena is from the Center for Migrant Advocacy in Philippines, which obviously has been a very important country in the whole advocacy for migrant rights. Pablo, are you there? And would you like to respond to her specific question about the GCM?
Okay, yes, thanks. Thanks, Ellen. Nice to hear from you. Someone that has been always very active in engaging with the committee. It's a critical question. I mean, if I would, reply based on what has happened until now, I would say I would opt for the second part of your question, that the GCM could lead to lessen interest of the convention and the committee. Why I say that? First, because in a way, not only the GCM, but before that, the GFMD, the Global Forum of Migration and Development, in a way that process directly or indirectly, intentionally or unintentionally, led to move almost all stakeholders, including many key civil society actors, to the non-normative framework on international dialogue or international discussion, global discussion on migrants, on migration policies and migrants' rights, because of a number of reasons. I don't have to develop more this opinion, but and we saw that in a way at the committee when we saw many times a huge mobilization of civil society at GFMD and GCM processes, and then maybe in some cases, in some occasions, we hadn't received any alternative report from civil society from from a state party, no? On a state party situation. So, and the second reason is the GCM itself barely mentioned the Migrant Working Convention. It's mentioned explicitly in one footnote, along with other human rights treaties, as if it were exactly the same, when it is, as I said earlier, the international legal tool, or the legal tool, or the key piece of international human rights law on this. So that's I mean, that's an indicator, no, in terms of which role some actors, some states want to give to the convention and the committee in this process. This is the more the negative reply, but I would have the positive one. I also think that this process, I mean, the discussion on the general on the GCM, can imply opportunities for, as Rima said, so making more visible the convention, making more visible this lively interpretation of the convention by the committee, the general comments, the recommendations to state parties. I would say that almost all, if not all, the issues included in the GCM have been addressed by the committee in either general comments or recommendations to state parties. So with very concrete tools, with very concrete recommendations on how something should be done or how shouldn't be done. So it's bringing the convention and bringing that lively language to different discussion of the GCM or the SDGs in a way can make the convention more visible and maybe with additional strategies lead to more interest and more ratification. Because in a way, I mean, the GCM process, I mean, apart from the different positive effects or contribution that any of you can think about, I mean, doesn't lead directly to having very concrete discussion on what's going on the ground in each state territory. A periodic review under the convention, I mean, allows that. I mean, just focusing not in very abstract way on some migration policies on some particular topic, but focusing in a comprehensive way on what's going on in every single matter related to human mobility and migrants' rights in a particular territory or more than one territory. So, but we need to bring that language to the GCM process. Unfortunately, there are two processes. I mean, in my opinion, that was not the best decision. There are some reasons because of that. Because as I said, I mean, the committee is addressing migrants, asylum seekers, and refugees at the same time because human mobility can't be divided with such a such weight, apart from the fact that there is a additional legal tool for protecting people through the Geneva Convention 1951 protocol. But so that's another additional aspect. I mean, so I think that we need to find that opportunities for bringing the CMW to the place that has to play in any discussion of the GCM, and bringing the commitments made by all member states in 1990. So I think that is an opportunity there. Yeah, so I'll say that. Thank you, Ellen.
Thank you, Pablo. That was given us a lot of food for thought in terms of future advocacy and engagement in these processes. I can see that Mike has his hand up, and you've also put some things in the chat, Mike. I'd like to speak.
Hi. Thanks, Rachel. And thanks for all the comments, everyone. And also for this really rich discussion. It's amazing to hear all the points of view from around the globe about the convention and the opportunities and also the challenges. And so I'd like to just step in quickly to provide a comment, picking up where Dr. Chowdhury left us and where others have picked up, including Ellen, with respect to the convention and the GCM and the interrelation there. And unfortunately for me, I have a bit of a pessimistic view of this, because in my recollection, in the lead up to the adoption of the New York Declaration and then later the Compact, it was a constant. There was a constant reminder that when people were speaking about the Compact, that the Compact was something new, and the human rights conventions were something old, and it was kind of like putting us all on notice that, to some respect, this was seen as a way of adopting a rights-based agenda without actually doing a rights-based agenda. And I think there's some strategic decisions that are being made globally today with that kind of background in place, where it's an end run around the conventions a little bit, even though there's lip service paid to them, as Pablo said in footnotes. So I'm afraid that there's what we see with the GCM is a bit of a symptom of a larger dilemma we're facing, which is how can states deal with this issue of migration in a way that makes them look good, but maybe is much more based on providing services rather than ensuring that rights are being respected. Which leads me to the next thing I have, and it's a question I want to put back to Pablo and also to anyone else who would like to speak up. But I think one of the things that's a theme of our discussion today is how can we make this convention more effective? And there's lots of different ways that speakers like Olga have mentioned, or Rima, how the convention represents a tool that can be used even when the state that the person may be representing or focusing on is not a member, but nevertheless the convention provides an avenue for promoting rights. And I think this leads back to this question of jurisdiction, which Pablo discussed, which is a very interesting one because, and this is a very specific question I have for Pablo, because although the committee, when it discusses the issue of jurisdiction, it does so in the context of member states and actions of member states abroad. Nevertheless, when we talk about jurisdiction and effective control and who may be supporting certain kinds of actions beyond their borders, it raises a lot, which is happening all the time with the issue of migrants and refugees and the detention of migrants and refugees and the externalization of immigration controls and asylum procedures. That does raise this intriguing question of the extent to which the committee sees the issue of jurisdiction as enabling them to address or comment on the activities of states that aren't member states, but that are impacting migrants from states that are member states, for instance, or in any other kind of context in which this jurisdictional control issue maybe implicates states that are non-members. I would be curious to know, Pablo, both from your previous experience on the committee and your current membership, to what extent have you seen the committee reach out that way to address issues or actions of non-member states to the convention? And that's question one. The second question I have, and it also deals with this issue of effectiveness, is it seems to me one of the important things that one of the important avenues we have for improving the effectiveness of the committee's work, and this is something that Rim talked about a bit with Gadem, is when these submissions are done, a lot of work is often done to make these submissions. And as some people have mentioned, the GDP has worked with lots of different organizations in trying to produce these submissions on specific countries as they come up for review. It seems to me that the submissions themselves become a living document themselves too. And it would be a shame if they just are sent in and then nothing's done. And obviously Pablo talked about follow-up mechanisms, but it seems to me that the submissions themselves can be can be tools of raising awareness and also for following up in countries about situations, raising awareness about what's being said in those submissions to help kind of use it as a lever for putting pressure on states. And it would be interesting to know to what extent anyone here today has used submissions, whether it's on immigration detention or any of the other issues that come up in the convention that they may have been promoting, whether they've used submissions in this way as a kind of a public raising of awareness and not just as influencing the activities of the committee and the questions it may ask. It'd be interesting to hear that. Thanks a lot.
Thank you, Mike. There's lots packed into those questions. And I just want to go back because Elaine has put a couple of comments just agreeing with what you said, Pablo, and saying that she feels that states are veering away from the normative framework and they see GCM more about a kind of principle pragmatism, which is what Mike was also just saying. And you have a comment about the Philippines, which is already a state party and bound itself to the realization of 23 objectives of the GCM. We will come back to that comment in a minute. But Mike had two real questions for you, Pablo. One was about the jurisdiction question. to what extent can the committee comment on non-member states? And the second was about effectiveness and how we can use these submissions as living documents and tools for advocacy. So it would be great to hear your responses to that. We've got 10 minutes left. So I just would also like to say, maybe leave a few minutes at the end, maybe to hear from anyone who is involved in any campaigns for ratification or sees any movement on ratification or has any ideas about how we can proceed with that. We heard from Rima that it's in the Gulf states, it's highly unlikely, so they're trying to find other avenues, but there are some more hopeful countries that may be moving towards ratification that we should hear about. Pablo.
Yes, very briefly. The extent of what the committee can do with what's going on migrants' rights protection in non-member states. One, it depends on the amount and of information we receive on what's going on in those states. I mean, not always the committee has received information from different stakeholders like civil society organizations that are working on migrants' rights in destination countries are submitting reports to the committee. That is a key piece. I mean, as always, in order to for us to get the more updated and accurate information on what's going on the ground and what can we take from that in order to make recommendations to the state party. Usually it's state of origin or transit that could impact the non-state party, destination party. So far we have been using that information or information that we gather ourselves, as I said, I mean, with recommendations through, I mean, if you sign bilateral agreements, you have to include this, and this, protecting migrants' rights, due process, monitor detention policies, deportation policy, family separation, the treatment of children, and so on. You have to strengthen free legal aid through consular assistance. You have to have children's rights specialists in consular assistance services, in consular services. You have to bilateral dialogue with the states of destination in order to promote this and this. So that's one strategy, and bilateral or regional approach, consular assistance, consular services, strengthening consular services as a way of protecting your nationals' rights abroad. Then, of course, but it's more indirect. I mean, as Olga said, I mean, using the convention and also Rima in a way as a soft law. I mean, the state parties, the convention and the committee's general comment, for instance, I think that is very important and it could be useful tools for promoting some kind of policy reform or in a case before a court, etc. Using those standards in non-state parties. Of course, this is soft law, but in a way, soft law produced by the single body that all states created 32 years ago for interpreting migration policies, interpreting migrants' rights. So I think in a way that's something that could be strengthened. And in terms of effectiveness of submissions, I do agree with Mike. I mean, in any single of these kind of strategies, and what the civil society and other stakeholders can do on the ground are the most important thing that in order to promote policy changes. And I mean, the committee is just a tool. I mean, so we receive information. Information is critical for making proper questions. It's critical for having a constructive dialogue, and then it's critical for making the actual recommendations that lead to some kind of actual shift on the ground. But then what is done on the ground is much more important than we can do. It's important that we do the right thing. We have the right information. We make the right recommendations. But then what is critical is what happened after that. So to which extent that recommendations become policy, become practices, and this is. I mean, this in a way, in terms of human rights in general, migrants' rights in particular, protection. I mean, this is the key step. And what we must do, and we are discussing that, is how to strengthen follow-up procedures, how to be closer to what's going on the ground, how to be closer to different stakeholders, either by virtual tools or in-person meeting, in situ visits, or whatever is possible in each concrete time, but we must strengthen that kind of strategy in order to cooperate with you, to cooperate in for pushing for actual changes.
Thank you, Pablo. And I see that Tatsi Makabaug from MFA has put a comment in the chat, but would also like to speak. And just to go back to Elaine's last point about, you know, what's the value of a country like Philippines that is a party to the convention, but has also integrated all 23 objectives of the GCM into state policy. Do you think that that will strengthen its commitment to migrant human rights? So it's a kind of another approach. But Tatsi, would you like to explain to us about what you've been doing in terms of education campaigns and trainings with CSOs on the CMW in your region?
Hello, can you hear me?
Yes.
I'm sorry I cannot turn on my camera because my connection is not very stable. I just wanted to share about the work of MFA in terms of information, education, and campaigning for the ratification of the convention. MFA, as you know, is a regional organization, and we work closely with our members in terms of organizing capacity building among civil society in line with how they can engage with the Committee on Migrant Workers and also with the UNSR on migrant workers. We have also been organizing information education with migrant communities themselves about the Migrant Workers Convention as a way of informing them about their rights. And we used to have an annual in-person training before the pandemic to organize all of these capacity building programs. We're trying to move this online, but also to add that even if during the pandemic, in Migrant Forum in Asia, we organize what we call the Migrants Campaign Month, which is a month-long celebration looking at how we can engage with governments more in terms of the ratification of the convention in Asia. And we have worked with our members, for example, in Nepal, in terms of looking at how the government can ratify the convention. And we have had several dialogues also with government representatives in Nepal, also a country of origin for migrant workers. But we also work closely with our members in terms of looking at how they can prepare submissions when their governments are due to give reports to the committee, at least for the countries who have ratified the convention. And maybe just to add, there's a lot of discussion about the GCM, but I think Abrar, Professor Abrar, Dr. Abrar was right in terms of we should engage both when it comes to national engagement with governments. There is a need to revive the campaign or to continue the campaign for the ratification, but also continue to engage with the GCM, given that a lot of governments are also looking at the GCM and IMRF. Countries are contributing, at least we know in Asia, countries are contributing reports in terms of how they are implementing the GCM. We have seen this in the regional consultations, but also we should not forget the push for the ratification of the Migrant Workers Convention because it's still very relevant and very important. Thank you.
Thank you, Tatsi. And that was a really, you know, grassroots perspective of what you're doing on the ground in terms of trainings and reaching out to civil society organizations and to migrant workers themselves and educating about the CMW and their rights under the CMW. And I think your last point that the GCM and ratification of the convention are not mutually exclusive was a positive one to finish on. I'm just having a look. And Elaine, you're saying the same, that you use the provisions of CMW for advocating for migrants' rights. It's the embodiment of migrant rights. So whether states ratify or not, you see the standards set forth as floor standards, which is definitely a very important point. I'm cognizant that we've talked a lot about ratification, we've talked a lot about the GCM. We haven't talked so much about the application of the convention in situations of detention, which obviously for our organization is a very important focus. But I think that Pablo really explained very comprehensively about how General Comment number 5 is such a useful standard on the rights of migrants who are deprived of their liberty. But we have reached the end of our time now, and so I think that we will close this meeting. I don't know, Mike, if you want to say any final words before we close.
No, just that was really a fabulous workshop and webinar, and I'm really pleased at the presentations that we've had today. Thank you, Pablo, very much for coming on, and for everyone who spoke. It was excellent. I think it was a really learning experience for many of us. So yeah. Fabulous.
I don't know if you want to put your videos on to say goodbye to everyone, but thank you so much. Thank you, Pablo, for educating us. It was such a fantastic presentation. And thank you to all our speakers who shared so much contextual information from your regions and countries, and also some of the real challenges you're facing and how difficult it is to work on migrant rights, and at a great cost. So we really salute you and wish you the best of luck in your continuing work, and hope that we as the GDP can continue working together with you in partnerships. And I see Pablo wants to speak. Just one last point from me is, if you are interested in doing a submission to the CMW, or in fact any other treaty body, do get in touch with us, because it's something we're very happy to work on with other organizations, doing joint submissions and supporting you in doing that.
Including the UPR too.
Yes, the UPR and the treaty bodies, and comments on general comments and thematic papers. So if you're not, if you need some guidance or would like to do it jointly, or need the cover of another organization for security reasons, we're always happy to help with doing that. Pablo, the last word.
Just to say thanks, and a brief call to those who are from state parties of the convention for working together on the ratification of Article 77. If the individual communication is in place, I think we can make a difference. I mean, through the case law that the committee will develop. Thanks.
Okay. Well, these sessions to be continued. So if you have suggestions about what you would like another information training session on, then do let us know. If there's another treaty body or mechanism that you would like more information about. But in the meantime, thank you so much. I will follow up. I'll share the recording. Pablo, maybe I can share your PowerPoint presentation, because there was a lot of information in there. If everyone agrees, I can also share the contact list of everyone present, but I might just ask for you, if there's anyone on the call who doesn't want their information shared, maybe you could send me an email and let me know. Otherwise, it's a great networking opportunity. Thank you so much.
Thanks.
And get some sleep, Sahar.
Thank you so much.
All right.
Bye-bye.
Thank you. Bye-bye.
Thank you. Bye.
Bye. Thank you.
Bye.
Bye-bye. Thank you, Pablo. Thank you.
Bye.